Professor Kuenzi is here. Thank you so much for joining us. I've already done some introduction, so I think I'm now going to turn this over to you, Professor Kuenzi. You should be able to share your screen. If not, I'm happy to. I have your PowerPoint presentation, so I'm happy to do it for you.
If you don't mind bringing it up, I think that would be fantastic. And I apologize for just joining now. I had a few technical challenges, but here I am.
Here we go.
Wonderful, thank you. And I'll just ask to advance the slides as we go through this. So welcome, everyone. I'm really thrilled to be here today to talk a little bit about my favorite topic, water law and our environment and the societies we live in and how important water is to that. So I'll just start with, I know we probably had some introductions, but I'll start with a little more about me. My name is Nicole Kuenzi, and excuse my voice, I have a little bit of a cold, so I have a large glass of water, which is appropriate, but excuse that if I need to take some breaks. But my name is Nicole Kuenzi. I'm an adjunct professor with McGeorge School of Law, which is a role that I really enjoy, and I'm thrilled I can be here today. In my other professional role, I'm the presiding hearing officer with the State Water Resources Control Board's Administrative Hearings Office. And the State Water Board, just to give a little bit of background, the State Water Board is the state agency that administers California's system of water rights. And the Administrative Hearings Office, or as the AHO as we call it, is an office within the board that was established by the legislature in 2019 to specialize in conducting water rights adjudicative proceedings, in other words, water rights hearings. We can stay on slide 1. We'll get to that. It's now, looks like it's scrolling through. And prior to that, I did practice water law in Colorado, so I have a particular interest in water law and water rights in the West. But of course, that extends really throughout the world because many of the similar issues are faced in many other places around the world, especially in those more arid climates. So in my role as a presiding hearing officer, I conduct, as I said, water rights hearings. That includes enforcement proceedings that address allegations of illegal water diversions, for example, or a failure to report properly water diversions in use. Other types of proceedings include water permitting proceedings that have to do with changes to existing water rights or applications for new water rights. So I get to see a wide range of issues that are presented throughout the state and that really are closely tied with the evolving challenges in water law that we face both here in California and elsewhere in the American West. Another process that we see in our office, which I'll just briefly mention because I think it's relevant to the larger issue and the question I'll pose at the end of this presentation, which is who should be making these decisions about water management. Another type of proceeding that we see are court reference proceedings, and these are actually matters that have been brought to the court in the line of some kind of lawsuit, some kind of litigation. And the court looks at these questions and thinks, gee, these are particularly technical and difficult and challenging for me as a judge who is not a water expert. And one of the options for the judge is to refer these matters over to the State Water Board for the board to prepare what we call a report of referee. And this is a way for the courts to tap into the expertise of the Water Board, which has specialized knowledge about water law and also the often complex technical analyses that go into water management and decisions and water law decisions. So taking a step back from that, I wanted to get more to the topic of discussion for today, which I really think is about the interconnected nature of water law and water management with the values of our society and the world around us. And I think, as I mentioned, one of the reasons that I've been so drawn to this particular area of law and study is because of the richness of the subject matter and the degree to which the history and the development of water law and water management, I think, really tracks the evolution of the needs and the values of our societies and our communities. So I'd like to start at the beginning a little bit, which is a short presentation, but I'd like to start at the beginning and track the development of water law, and particularly Western water law, because that's where I'm most familiar. But I think this story about water law development provides us context about where we are today. So if we can go ahead and go to slide 1, which we've been anticipating here. First, I'll just, to start at the very beginning, we'll go to time immemorial. I would say since time immemorial, water has been recognized as a resource to which all peoples as human beings have an inalienable right, because water is necessary to life and water is necessary to the thriving of our communities. You can see here a depiction from the ancient Egyptian culture, a depiction of the Nile River and its importance to that community. We see in the cultural practices of native peoples throughout the world the recognition of water as life. We see this theme as depicted here in the rise and fall of the ancient Egyptian civilizations and their dependence on the seasonal patterns of the Nile. We see it in the statements of the Roman Emperor Justinian, who is often quoted and credited to have stated, "By the law of nature, these things are common to mankind: the air, running water, the sea, and consequently the shores of the sea." And I think we could point to countless other examples throughout the world and throughout history of this recognition that water is special. It's limited in resources, and it's absolutely essential to life and our societies. If we can go ahead and go to slide 2, please. So I have here a map of the United States. This is, I believe it's 1870, a map that depicts some of the rivers and waters of the United States. And I wanted to give a sense. You can see here a little bit, I know it's a little bit small, but you can see here a little bit the difference in the Western United States versus the Eastern United States in the number of rivers and the proximity of those rivers to one another. So in the Western United States, most of the territories before entering the Union as states initially drew on the English common law as their default source of law. And the problem with this approach with respect to water management and water law is that most of the American West is, of course, not at all like England in its weather or geography, and it's actually not at all like the Eastern United States in its weather or geography. And that created some problems. The Pacific Northwest maybe is an exception here, but they have their own challenges as well. But with the exception of the Pacific Northwest, here in the American West, the climate is primarily desert-like. It's quite arid, or at best a Mediterranean climate where you may have wet periods, but then dry periods as well. There's a lot of variability in the climate, and that climate has continued to change over time, the particular patterns. And this is an example of why it's so important, I think, for the law of water to take into account the specific hydrologic realities of any particular region. Because if you have a water law that doesn't match what you have on not even on the ground, but coming from the sky and in the snowpack and underneath the earth in the form of groundwater and in the lakes and rivers, you're going to have a mismatch and you're going to have difficulties in managing that resource in a way that's supports the values of the society. So under the English common law, all owners of land adjacent to a water body had a right to a communal share of the water. So then I would ask you, if you think about the American West and how far apart our rivers and streams are in many places, well, what happens if there's no river or stream that runs through your property? Well, that would mean you would have no water right? Or if the water in the river or stream is not sufficient to satisfy the needs of all who would draw on that water source, there's just not enough water in the river or stream. For example, you might imagine, should all the farms fail in a particular area because an equal share of the water is not sufficient to satisfy anyone's needs? If you take the pie and divide it up too small, maybe no one gets enough. And then you might ask this question: is it fair that a settler who came to the region first in time and then invested the time and resources in a farm and the construction of irrigation works and the plowing of the fields, and then later, 30 years later, has to share water with someone who is newly arrived and purports to make an equal claim to that water? Is that fair? And in another twist of the story of the American West, which also didn't fit with the English common law, what if you didn't own the land? Well, then you don't have riparian rights. Many of the Western lands were public lands and still are public lands. And there's therefore those who essentially were squatting on those lands. Sometimes they were intending to ultimately make a claim to them, and sometimes not. They would arguably have no legal rights to that riparian water. So we needed a different system. If we can go to the next slide, please.
Yes, but before we do so, we have a questions.
Oh, great.
The question is, what do the green and orange colors indicate on the map?
That's a good question. I can provide the resource where I pulled this. I think these are generally the different regions. It was 1870. It was probably viewed as different regions from a hydrologic perspective of the amount of rain. I don't know why the Southwest region is colored green, which we usually think of as wet. That would not be I think the right the right view to take from this map. So I actually don't know what the cartographer was thinking here. But I thought it was a useful map in terms of showing those rivers and streams. So here we have a depiction of miners, and I had mentioned miners as an example of those so-called squatters on public lands. Here are the gold miners in California. You can see gold mining was water intensive. You needed water to gold mine. You needed it to pan for gold, to wash out the gravels. Often miners were engaged in rediverting creeks and streams and sometimes whole rivers to try to get to those gravelly areas or areas of rock where they thought they might find gold. So water was an essential part of gold mining, and it's part of the story, at least for California water development, that was very significant. The miners sought to use and divert water for gold mining and were very much competing for that use, just as they were competing for their individual mining claims. You really didn't have, depending where you were and the type of mining you were engaged in, you couldn't have a good claim unless you had the water to process the rock in the way that you needed to. And in part, so from all of this context, the miners of California, the settlers in the broader western region of the territories, this arose, it was the right situation to give rise to the doctrine of prior appropriation. And this is the concept we have in Western water today of first in time, first in right. If you were there first and made a claim to the water first, then it's your water, generally speaking. I think that this is a good example of a society, and that's very different from this riparian concept where it's based on property ownership and also a correlative share, a sharing of that resource among property owners specifically. So I would argue that the doctrine of prior appropriation is an example of the society really creating a rule almost from the ground up, kind of a grassroots rule for allocation of this limited resource that would work better in this specific legal, geographic, hydraulic, and societal context that was in place at that time. Or at least, and I wanted to certainly give the caveat, at least worked for those who were integrated into the controlling governance structure. I do want to recognize that the needs of Native populations and others who were not property owners or were not actively involved in governance may not and were not recognized in this development of the prior appropriation system. And as this occurred, and then prior appropriation took hold in California and throughout the West, it actually took stronger hold in most of the Western states other than California. Society continued to develop as it does, right? More lands were irrigated. Mining became more challenging and required more and larger machinery and greater amounts of water. And the cities grew, both in Northern California and Southern California. You see the phenomenon in Colorado as well, where the municipal areas, urban areas on the eastern side of the state grew faster than those on the western side, whereas most of the water falls there on the western side and not on the eastern side. Similar mismatch in California starts to occur where you have most of the water supplies in areas that are not the urban areas and are quite distant from them. So as this occurs, we see a shift from needing a legal structure like prior appropriation that allocates this limited resource from the public domain into some form of, I would call it quasi-private ownership, to needing more of a legal structure that accommodates these competing demands for this allocated resource of which there just isn't enough. And this is where we start to really see conflicts that arise in Western water law that tests this doctrine of prior appropriation and whether this system can work over time. We start to see these conflicts between different types of water use really early on. There was a very important case in California out of the Supreme Court in 1884, in which the California Supreme Court functionally prohibited hydraulic mining because of the huge amount of tailings that were washed into the river. So these were situations where gold mining was occurring using these extremely powerful hydraulic pressured hoses, if that's the right word for it, or cannons, that washed all of this gravel and tailings out into the rivers In that particular case, it was particularly the American River, but it flowed all the way down into the Delta and out towards the San Francisco Bay. And the problem with these tailings is that, I mean, it raised the bottoms of the river by many feet. It clogged up the river for purposes of navigation, and it made the water quality bad. It fouled the quality of the river and prevented it from being used for domestic and other purposes. And that was a real problem. And the California Supreme Court said, no, this hydraulic mining, you can't do that. That's a public nuisance. And it's an example of the court making what I would call a value judgment about which of these uses of water are more important and which are more valuable to our society as a whole. And we'll see that these value judgments play out again and again in water management decisions, and you'll see them all around you, because water is limited and is necessary. So these difficult choices need to be made over which use is more valuable than another. Another example of conflict is in the place of water use. And I alluded to this already, that water is often in the wrong, what we think of as the wrong place, right? It's not where we want to use it geographically. And then it has to be, if we want to use it, where we think we'd like to use it, it has to be transported long distances for use somewhere else. Some examples of this from California are in 1913, when Congress authorized the construction of Hetch Hetchy Reservoir. I think we can go to the next slide here. I think I have a Hetch Hetchy. There we go. So this is just a picture of Hetch Hetchy Valley before it was dammed. And it was actually within Yosemite National Park, and Congress made the decision at the request of the city of San Francisco, city and county of San Francisco, to allow the construction of a huge water project there to supply the city of San Francisco with much needed water. San Francisco had limited supplies. They're located on a peninsula, which doesn't have a lot of natural access to stream flows. And their intent and what they did do was to create a reservoir and transport that water to the city so that the city could continue to grow and thrive. And there was a lot of debate at the time about whether or not this was an appropriate choice. And there continues to be a lot of debate about whether this continues to be an appropriate choice. But it's another example of these value judgments about how water should be used. As we move along, this was 1913. In the late 1930s, another example of water transport is Congress's authorization of the construction of Shasta Dam, which was an important element of the Central Valley Project. And that project, as it's been fully developed, supplies agricultural water to the southern portion of particularly the southern portion of the Central Valley, which has productive farmlands, but not as much water as there are farmlands. And that was once again a value judgment. And following after the Central Valley Project in 1960, the California legislature approved financing for the construction of the State Water Project, which is similar in many ways to the Central Valley Project, and allowed for the construction of infrastructure to bring water from Northern California to Southern California, in that case primarily for municipal use, as well as some agricultural use. So these were major projects and reflected the judgment that the water was best used in places other than where it originated. Now, in this development, I think we can go to the next slide, please. See, there we go. What's next in this history? And this is a very general history, but it just goes to show that how things change and relatively quickly. We have approval of the State Water Project in 1960, and then what happens in 1969, once again using California as an example, California passes fairly rigorous water quality legislation, and a year later passes the California Endangered Species Act. And then shortly thereafter, we see the same from the federal government. The federal government passes the Clean Water Act in 1972 and the Federal Endangered Species Act in 1973. And this is generally the time of what we call the environmental movement, and a recognition and a shift of in choices about management of the environment, and particularly water management, and how we're making those choices. So that really, I think, is reflect a big shift that we're continuing to adapt to today in adding a significant consideration into our water management decisions that really previously hadn't been a part of those choices. Another landmark decision from the California Supreme Court occurred in 1983, in which the court directed the State Water Board to consider the public trust and protect the public's interest in trust resources, which includes things like navigation, fisheries. It's been since understood to include other types of ecological considerations and environmental considerations. And the court directed the board to consider those interests in trust resources whenever feasible. So it imposes this, in a way, a balancing test. And in this case, the particular issue was a determination of whether to essentially continue to allow Los Angeles to divert water from tributaries of Mono Lake, which diversions were causing rapidly declining lake levels and as a result threatening millions of local and migratory birds who visited the lake on an annual basis. And the Mono Lake conflicts continue. It's a very interesting and long story that I haven't gone into any detail here, but it's a great example, again, of seeing the conflict in values of allowing water to be transported from its original location to other remote areas for perceived higher beneficial uses, and the thought that maybe we should be reconsidering some of these decisions, or at least making these decisions in a different way. We see the same shift and conflict in the over management of the Delta, the San Francisco Delta in California, which is significantly impacted by the operation of the State Water Project and the Central Valley Project that I mentioned, which between the two of them transport in some years millions of acre feet of water out of that system to other areas in the state. And then finally, I think we can go to our last slide, please. It's just a visual for us. What I haven't mentioned yet is groundwater. I'm not going to go into great detail because that's a whole topic in itself. But remember, there's groundwater too. That is another area of water management that is very, very important, and that is also developing and I think reflecting the values of our communities. Historically, in California, groundwater management, I'll say, was just ignored where it could be ignored. In certain coastal areas, we couldn't ignore it. Early on in coastal areas, we started to see problems that resulted from pumping water from the groundwater basins that exceeded the natural sustainable yield of those basins because it caused seawater to intrude into the basins. That salty water from the ocean crept into that groundwater basin where there was space created by essentially over pumping. That salt water would foul up the fresher groundwater in the basin. And as the salinity progressed, it would intrude as far as some of these supply wells that had previously been used and then no longer could be used for domestic supply or agricultural supply. So as early as the 20s and 30s in Southern California and certain areas of the Central Coast in California, where there was this significant reliance on groundwater, we saw attempts to grapple with this problem. There were some adjudications, there were physical solutions put in place to inject water and create these seawater barriers. But in other areas of California especially where we weren't on the coast, there was no management and pumping continued and there was no organized response until we got to the drought of approximately 2011 to 2017. And that drought just brought in relief, and you can see this slide shows some of the areas that were significantly impacted by the drought, and the groundwater levels were significantly impacted. And it just brought to focus and a lot of attention on the fact that we could not continue to deplete the groundwater resources in this way. So in 2014, really a direct result of the drought, I think, as a catalyst for a change in the water management system, we see the Sustainable Groundwater Management Act, which requires local management of groundwater resources. So that's an interesting choice. This was a decision to leave some of these value judgments to the local regional areas that overlie these groundwater basins and allow them to make plans as to how they want to manage those resources and make these value judgments as between different uses of water. But the requirement is that they do have to achieve sustainability, that pumping in excess of the amount of water that's returned to the groundwater basin cannot continue, as that will it's not sustainable and is not the way we want to manage water resources within the state. And just as a final note on drought, I think drought is a catalyst for changes in water management. It's been a really important theme. It's a period of time in which political interests and people get really focused on water rights and water management and water issues. So we saw this. There was a significant drought in California in the early 70s, and then again more recently. And of course, we've had periods of drought throughout. And that is really a time when these big shifts in water policy tend to happen, I think both here and throughout the West and probably throughout the world. And then going forward, I just wanted to make some final comments about looking to the future and looking also to all of you who are thinking about possibly a career in water and water management or maybe have careers in water and water management. And my thought is I'm optimistic. I truly am inspired for the future of water management, both in California and throughout the West. I think there are opportunities for the law to continue to evolve. I mean, in some ways, it seems like we're always a bit behind the curve. In other ways, though, the law has evolved, either through evolution of the common law or through adoption of new legislation. And that these evolutions continue to reflect the current values in our society, which are changing. I think there are also opportunities for the law to be administered more fairly and effectively, including, importantly, through the inclusion of viewpoints that were not historically at the table in discussions over water management. I think that's increasingly apparent and on the minds of those that these decisions may have been different if other voices were at the table. And I also think there is a need and an opportunity for creative thinking from many, many ranges of professions and careers that touch water management, from hydrologists, geologists, biologists, legal practitioners, policymakers, mediators. I think mediators have a very important role in addressing these water management conflicts. And then also those interested members of the community, and that we can think about these complex water problems in new ways. And we also have the opportunity to apply modern data and tools and scientific approaches to these problems, which we didn't have the opportunity to do in the past. So I think although ultimately there will have to be value judgments, right? We will have to prioritize, but I also think that water management is not what I would say an entirely zero-sum game. There are opportunities to increase the size of the pie, but there are also trade-offs and choices. And I think actually one of the most important questions that we face in the appropriate governance of water in California and throughout the West and really throughout the world is the question of who in the governance structure, or there may be multiple touch points in the governance structure, should be making these types of choices about water management. How should we be making these decisions? Who should be involved? How are these decisions best made? And I think that's a really fundamental question for good governance of our limited water resources. And it's also a wonderful opportunity for the future to think about what your role might be in those choices, if that's a career choice for you. So with that, that's all I have. Excuse me.
Thank you very much, Professor Kuenzi. We do have a good number of questions. So instead of waiting for the end of the presentation, I'm just going to go ahead of the entire presentation. I'm just going to go ahead and ask you this question. So the first question is, does the State Water Resources Control Board handle irrigation issues such as farmers exhausting aquifers?
Excuse me. Let me see if I can get going here. Okay. So that's a great question. And that has to do with groundwater management. The State Water Board actually has a limited role with respect to groundwater. Or I should say, not as extensive as with respect to surface water management. So groundwater management in those basins that have been designated as subject to the Sustainable Groundwater Management Act, it's actually the local groundwater sustainability agencies who are going to be working with farmers and setting potential limits on irrigation practices and extractions. And that will primarily come from the local community. So it goes back to that choice that I talked about as a local decision. You know, how are we going to manage these resources? One example of locals working together, this is not groundwater, but I think it's a really interesting example, is up in the Russian River Valley, where there were problems with the use of water for frost protection. So at certain times of the year on the vineyards, at certain times of the year, the way to protect the grapes from frost is to actually spray them with water, which I find counterintuitive, but it protects the grapes from frost. But it meant that several nights out of the year, everybody in the Russian River Valley was pumping water out of the river to put on their vineyards, and it would dewater the stream and kill all the fish. And that was a real problem. But the creative solution there, which worked fairly well, or has been working, was to work with the state water board and other regulatory entities and construct ponds and other holding facilities where water could be pumped actually over time, so not all at once on those same cold evenings, but over time, and then applied on the grapes as needed during those cold periods. So that's an example. That's what I'm talking about this creative management. And they're similarly, I think the GSAs are being tasked with thinking about these trade-offs of demand management, infrastructure development. Can we get more water into the ground so that we can pump more out, or do we have to just reduce demand? All of these trade-offs are part of that. But really with groundwater management, the local GSAs go first, and then the state water board is under the structure of SGMA, only gets involved if the local regulatory agencies aren't able to achieve that sustainable management. We're sort of the backstop if that were to occur.
Thank you. Another question is, can you talk a little bit about the issues and implications around chemical contaminations in general, from agricultural and forestry chemicals to oil refineries and chemical plants?
Well, that's a big topic. I mean, I certainly can briefly speak to that. It's something I did do some work for the Los Angeles Regional Water Board, where there was a significant issues with petroleum contamination in some area and others in some areas. Once again, as it's less related to water law. That's more of an environmental law issue, although there's obviously crossover where you have contamination, whether it's seawater is one example, or petroleum contamination or other types of contamination that seep into the drinking water or agricultural supplies. Throughout the Central Valley, there are problems with nitrates from historical fertilizer use that has contaminated groundwater supplies. And these are ongoing problems, and they're very difficult problems. Once again, I think, like in parallel to water rights law, to which I was primarily speaking today, it's really going to come down to a collective action solutions, especially when you have a contamination problem like in the Central Valley with nitrates, where it's throughout based on this historic fertilizer use. It's not specific to one bad actor, if you will. It was more of a cultural practice that has since been revised. In the Los Angeles region, and when there's particular chemical spills, things like that, there's a whole body of law figuring out who's responsible for those types of cleanup projects and Superfund sites and those kinds of things, which is also a fascinating area of law and a really important area of law, because we see these contaminations from industrial uses, mining, a whole range of things that can significantly impact our communities and the quality of life in those communities.
Yeah. Is there a hierarchy of threats to salmon and fish? And if so, what are the most egregious threats?
That's a great question. I mean, that's a debate, right? What is that? I think, I won't say everyone agrees, but certainly not enough water is typically one of those threats, right? And that may sound obvious, but actually it's, speaking of trade-offs, I love talking about trade-offs. I'm going to go back to the Russian River again, because that's such a good example. One of the interesting factors there is that actually flows in the Russian River, at least historically in the summer, and this just goes to show how complex the systems are, but the flows there in the summertime, when there was typically the natural watershed would have been dry, most of the summertime flows were actually imported in from the Eel River across the mountaintop from a project by PG&E to create electrical power. And it just so happened it worked out, and had been going that way for over 100 years. So the Russian River Valley had come to depend on this supply that would come in the summer, and it was just these offlows from PG&E, who was producing electricity, and they would pump that water over, not pump it over, but produce the electricity and release it down the Russian River Valley. And those flows supported recreation in the summer, canoeing, swimming. Many people have fond memories of going to the Russian River and playing in the river in the summer and boating on it and doing all these things. Well, it turns out higher flows on the Russian River in the summer are not good for salmon, not good for steelhead. What do you know? So it's an interesting conflict between what was there naturally and other recreational opportunities. And so that's an example where I want to say, when I say often flows are a problem for salmon and steelhead and fish. It's not always the case. There's almost always an exception to the rule. So having flows there, there's also significant concerns about natural flows. There's more and more science about the need, and I'm not a biologist by any means, but there's more and more science about the need for high flow events that occur, whether it's every year or every 10 years, that scour the river channels and create habitat for fish that would have naturally occurred. And because we're managing rivers and streams through reservoirs and preventing those flood flows, often for good reason, to protect people and property and things like that. But it means that we don't have these natural events that would have otherwise occurred and would have otherwise produced these habitats. And so one of the questions is, how can we possibly mimic those through other means? Are there things we can do? And that's often why we talk about non-flow mechanisms to assist with the fish populations and other aquatic species. There are things other than flow that can also be done to enhance the opportunities for spawning and rearing for the anadromous fish and reproduction and habitats over summer. That's often a concern, is whether there's significant or sufficient habitat at the right temperature for the fish. Different fish species need different temperatures to survive, and especially in the summer when things get hot, it's hard to find those. But there are other mechanical ways that aren't just flow that we can address some of those problems. So I don't want to put it in a hierarchy, and I'm certainly not a biologist, but I would say diversions from the stream and then also changes to stream flows from management, and sometimes because we're holding back those flows at reservoirs at the top of the watershed, that can cause non-flow impacts to the habitat as well.
Thank you. We do have a lot of questions, and I know we're running out of time. So, okay, the next one is a little longer. So, to my knowledge, surface water and groundwater are governed by vastly different policy structures that really convolute the way water management for these resources can be understood. I work in water management for the Department of Utilities in Sacramento. There is a constant dance between distributing and using surface water versus groundwater, depending on the outflows and levels of the groundwater table. In the legal field, is there any conversation about looking at water law as a holistic realm rather than segmenting the law and policy by the sources of the water?
That's a wonderful question. The answer is yes. And actually, I think it's fair to say in most of the other Western states, it is unified. In Colorado, they have what we call a unified system, which means groundwater and surface water are managed the same. I mean, there are different considerations, but generally speaking, they're managed the same, and the same laws and rules apply. In California, that historically has been different, although, excuse me, I will note that the priority system for water rights between groundwater and surface water is integrated. And that's an element that has been, I think, sometimes overlooked in the law. If you do have evidence that a system is interconnected, although the state water board's permitting and licensing authority and enforcement authority is limited primarily to surface water, the priority system is not limited to surface water or groundwater. So in theory, if you have an interconnected system, where water is in a stream and is connected to that groundwater system, those water rights, and you have appropriative groundwater rights and appropriative surface water rights, riparian groundwater rights, riparian surface water rights and overlying groundwater rights, those are all integrated if you think about the source as a whole. I think the problem is we don't have governance structures that really think about the source as a whole. Under SGMA, there is some hat tip to this, I think maybe more than a hat tip, because one of the undesirable results that need to be avoided are significant and unreasonable impacts to surface water. So it does contemplate that there needs to be a management of groundwater that considers the impacts to surface water, because those systems are connected in most cases. And so that will be interesting to see how those considerations start to play out in the management of groundwater in those connected systems. But I agree, it's a challenge. It's a challenge to have different governing bodies governing groundwater versus surface water. But I think we're taking steps in California in the right direction. There's more we can do, but we're taking steps forward in the right direction. It also brings up this concept of adjudication of water rights, which is the process of taking a watershed and considering all of the water rights there and firming up, if you will, and declaring through a judgment from the court who has what rights. And that's another opportunity, I think, to really integrate groundwater and surface water rights. But the problem is historically in many of our adjudications in California, it was either for surface water or for groundwater. They were somewhat rarely included both.
Thank you. So there are many more questions. I'm going to go ahead and ask the last question, and I'm going to put my email address in the chat so people, you can email me your questions, and then I'll connect with Professor Kuenzi and get you an
Great.
answer. So the last question is, can you talk a little bit about the skills that you teach in your water law course? Like, obviously you cover like a lot of what you mentioned as far as the theory, but what are the skills that you teach?
Well, I'll talk about what I teach. I have taught at McGeorge both water law, and I also, one of my primary courses is it's called the executive branch and the administrative state, which is a course about administrative law, but in what I would say the most fun way possible. It is about the process by which administrative agencies, not just in California, we look at both the federal APA, the federal agency structure, as well as examples from California, and how those agencies function and how they work, how they accomplish the goals that are set up for them in legislation, accomplish their functions. We look at the process of rulemaking, the process of agency adjudications, and how those functionally work, how those decisions are influenced by external and internal forces, how you can influence agency action. So I try to make this a course that is approached really on all subject areas, although I do say there is an emphasis in my examples on water law because that's my area of practice. So that it really gets into how you can influence these decisions, whether you're an interested party or whether you were someone within an agency crafting these rules and regulations or having to deal with these administrative decisions. Now, in the water law course goes over the basic, everything we talked about today. It goes through the basics of the history of water law, why we are where we are today, the basics and the complexities of prior appropriation, the riparian system. We have both in California. The different methods of managing groundwater and surface water, the role of the state water board, the role of these large transfer projects that we talked about. So it's really all the things I touched on come up in that course, and really gives you, I think, a sense of a starting point to start to understand, because water law is something you can devote your life to, as I've done so far, but a starting point for you to really understand the conflicts, the complexities of what's happening around us, and the current conflicts in water in California.
Thank you. Thank you very much. I'm gonna stop sharing this quickly, and I'm gonna quickly move to my other presentation. So as Professor Kuenzi mentioned, like, she teaches 2 courses, and so our MSL program, for those of you who are interested in taking this a step further and really to have a career in this particular field and to have the legal knowledge to help you advance in this career. We have our MSL in water and environmental law. We have 3 other fully online asynchronous master's program and 3 hybrid program. But so for this particular MSL program, I wanted to show you with a limited time, like the list of courses that we do offer that pertains to this particular area of law. We are constantly developing new courses, and we're getting feedback from students on the type of courses that they would want to see in the future. So we may also have a land use course that we will develop, like, to be fully online. All of our online MSL students are allowed to take some of our in-person classes. I do realize that many of you decide to do an online because you cannot come to campus, but every once in a while we do have students, we do have students who are local, like, and who do want to take advantage of these opportunities. So as we mentioned, like our program is asynchronous. That doesn't mean that you're on your own for 14 weeks. We work on a semester basis. That just means that on a weekly basis, you have deadlines and a homework to fulfill, but you have like weekly deadlines. You just have the flexibility to watch the lectures and to do and to complete those projects that are assigned to you at a time that is convenient for you. Most of our professors do host those Zoom optional synchronous like office hours or happy hours, depending on the professors, however they present that. So just to create a little bit of that, try to recreate a little bit of that face-to-face interactions. However, I would say that all of our courses are developed to encourage a lot of interactions, not just between the professors and the students, but also amongst the students. So they are on a weekly basis, you'll have some ungraded quizzes, some discussions, there's also a chat that is structured for learning that is ungraded. And you have regular feedback from the professor. On all of your assignments, the professor do post feedback. And finally, I think this degree is, we do have a lot of students who already started their professional lives. It's not the case for all, but often it is, or it's people who are hoping to work full-time while doing the program. And so we do put a strong emphasis on practical, real world, excuse me, that was a mouthful, assignments and skills. So with that said, we are right now enrolling for this fall. Our application deadline is June 1st. After June 1st, we will still review application, but it's only, and we will admit only if we still have room in our program. Our classes tend to be small. We cap most of our classes at 15 students, but I think 10 to 15 is the average for our classes. So I know we started a little late. I have a little bit more time, so I'm happy to stay to answer questions about the program. I'm sure that Professor Kuenzi, you have tons of other things to do. So I appreciate very much your time and your presentation and you coming today. I've put in my email address here. But yeah, so thank you very much, everyone. I will stick around for a few more minutes if anybody has any questions about the program.
And thank you so much for having me. And it was really a pleasure to talk with all of you. I appreciate it. And I look forward to your questions. So thank you very much.
Thank you. I will post the URL in the chat. I'm assuming you are referring to the URL about the program. Let me go ahead. So here's the link for that I had on my previous slide for the application. And from this link, you can also access the information about our MSL program. The professor who's developed this online degree is Professor Jennifer Harder. Although she was not here today presenting or moderating the talk, I know she's also available to answer any questions you may have. And if you want to connect with her to have more conversation about the program and how can this help with your career, again, send me an email and I'm very happy to put you in touch with her. So question about the application. we only review applications once they are complete. If when you submit the application, we have not received all of the letters of recommendation, we won't review the application. However, so there is a little hold there, but I really encourage you to submit your application now, even if you don't have, even if your recommenders have not submitted their letters. I can look at. I don't know if you're able to remove somebody that you listed for as far as a reference, but you can certainly add one more person. It's okay. We often have people listing 3 people and only 2 or 1, submit a letter of recommendation. This happens very often. So as soon as your application is complete from our end, as soon as we receive a letter of recommendation, we go ahead and process your application, assuming that everything else is complete. If you want us to wait for all of them, we certainly can. You just have to email us to let us know. Okay, well then, I will go ahead and review. I'm going to make a note. I'm going to go ahead and review your application, and I'm going to then connect with you via email or call you to talk about your application. Thank you. I'm just I know you send me some, questions, but I'm trying application documents and are confidential. So I think it's best for us to take this one-on-one. Any other questions? Well, seeing none, thank you very much for your time, and thank you for your patience at the beginning of this webinar. Have a wonderful afternoon, everyone.